interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My Lord, the public interest that has been propounded by at least the response by the Attorney General, or the application that by the Attorney General, did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My Lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My Lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My Lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IEBC. My Lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My Lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my Lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IEBC is a political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My Lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IEBC if really there is a political crisis. Finally, my Lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. Because they kind of explained how conservatory orders ought to be interpreted. And my Lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my Lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. Because one of the things that is considered by all parties in this case is that an impeachment did happen. And it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done, as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my Lord, I want to talk about the Wajir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wajir case relates to a governor who was impeached. the deputy governor assumed office and then even nominated a new deputy governor, and then later on the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My Lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the two cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is the question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My Lord, it's the political arms of government that can deal with that. And that might be one of the issues that are political questions that the court cannot really address. So, my Lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My Lord, thank you very much. I'd like to ask my co-petitioner, I think petitioner number 12.